like to, first of all, begin by letting you all know, if you have not seen this yet, PTAA is in the middle of a really big food drive now with our support and in our partnership with Second Harvest Food Bank. So if you are able to donate now, you can go to our website, look for the food drive link. And the really cool thing about right now, sorry, the really cool thing right now is that when you donate right now, our ECHO committee is going to match your donation up to $200 in the month of May. So it expires at the end of this month. And the really, really cool thing about that is that that is also matched by an anonymous donor. So that $200 could very quickly turn into $800, which feeds a whole lot of people in need right now. So thank you for considering that. The other thing I'd like to remind you is with this webinar, it does include one CEC for you. I will be emailing you your CEC certificate by the end of the day tomorrow, so look for that. So whatever email address you registered in this webinar with, that is the email address I will send that to. So without further ado, I'm gonna pass the baton over here to Michael Bell and enjoy the webinar, you guys.
Thank you very much. Good to see you, Carrie. So welcome everybody. For those of you who haven't met me yet, I'm Michael. I'm with Loebsack and Brownlee, Director of Client Relations, and we are the law firm that handles your, many of you, we handle your evictions. So if there's ever anything we can do for you, please reach out, let us know. At the end of the webinar, Carrie will be sending out a follow-up email like she mentioned, and in that I'll make sure she's got links to any of the documents that Chris shares today. So as he's going through that, if you want to see a copy of it, don't worry, we're going to send out the links. We don't have chat enabled because sometimes that gets a little out of hand, but we do have Q&A turned on. So if you have a question that's pertinent to today's topic, please put that in the Q&A. I like to say wait until about 30 minutes in. We'll be here for about an hour. Wait a little while because Chris will probably cover it anyways if a lot of you are thinking about it. If he doesn't get to it, throw it in the Q&A. You'll have the ability to upvote. So if someone else has already asked it, give their question a thumbs up and it pushes it to the top of the list. And then every so often I'll interrupt Chris and ask him a few questions. We'll try to get them all covered. But that's it. So the Q&A button, for those of you looking for it, if you're on a computer, it's at the bottom of your screen. If you're on an iPad or an iPhone, a smartphone of any kind, it's underneath the 3 dots. So you should be able to see those 3 dots and then click Q&A. So anyways, Chris, thank you for being with us this morning. I'm going to turn it over to you. And then once you get rolling, I'll share my screen with those things that you want to talk about.
That is awesome. Thank you, Michael. As always, the master of ceremonies. Michael and I have gotten pretty good at, at this little spiel. We've done a number of these webinars now over the last couple of months. And so everybody who's on today's webinar, thank you for joining us. Today, I'm going to talk about fair housing issues. It is now May 21st, but the impetus for this one was in April. Every year, the Department of Housing and Urban Development has declared April Fair Housing Month. And so every year they pick a different fair housing focus topic. And this year's focus topic was sexual harassment in housing. And so while it's not April anymore, I think this is a topic that a lot of people are just now getting tuned into. And I think that's exactly why HUD chose that as this year's topic, because they want people to be more aware of it and to really turn this into something that we spend a lot of energy teaching. Now, I've taught some fair housing for the PTAA over the last year or 2 years, and have covered an issue like this in my seminars because the fair housing issue of sexual harassment in housing came up in 2016 when HUD created a new rule that laid out what sexual harassment in housing is and why it is a fair housing issue. So this is a relatively new topic. And so given that it hasn't yet gotten a lot of traction nationally, I think HUD chose to make it a focus, and that has already been noticed by various other officials at the government level. And so we're going to spend some time talking about what HUD does and doesn't define. But in addition to that, we're going to also spend some time here early in the seminar talking about COVID-related issues and how they affect fair housing in today's real-world environment. This is a very much a test tube that we have not seen before. And so in the coronavirus resource and guidance documents that that NAA has put out, there's some really good stuff. And we'll focus on one of the great guidance documents they have, rent collection amid COVID-19. They put that out at the end of March, but it has a lot of topics in there that are, I think, very relevant, and there's a lot of fair housing issues that are hidden inside of COVID response, changes in your protocols, and now changing your protocols back. Now that we're coming out of lockdown and we're getting back into things, there's some fair housing issues there too. So we're going to try and touch on a lot of them and really sort of do some issue spotting and hopefully help you cover a number of things today that will prove to be relevant. Now, those of you that have seen me teach before, you know that usually in a classroom setting, I very much encourage everyone to raise their hand and let's answer your questions while we're talking. And so in this virtual environment, Michael's job is to field those and lob them into me. So please do what you usually do with me, which is lob your questions in as you think of them. While I'm talking about the topic, it's a lot easier for me to answer the question in the flow of the conversation than it is to try and go back later, or at least that's how I feel about it. So please do lob them in. Michael will do his best to interrupt me and then let me answer your question so we can get to it while it's fresh and while we're on the right topic. All right, so dealing with the sexual harassment and housing piece, just to start with, the Fair Housing News Bulletin that was put out back in April by HUD, they actually labeled their campaign for April's Fair Housing Month as "Call HUD because sexual harassment in housing is illegal." So those of you that have listened to a fair housing seminar by me before will tell you'll recall that I almost always talk at the beginning about how the fact that the Fair Housing Act has basically been the same for the 40 plus years it's now been in existence, but yet every time we turn around, there's a new fair housing topic to talk about. Why is that? It's because most laws, especially big ones like the Fair Housing Act, are really living documents. They are constantly being updated. There are always new rules being enacted that relates to the Fair Housing Act, even though the law itself doesn't change very often, other than periodically we add a new protected classification. Every 10, 12 years we get a new classification added to the list. Last one that got added was familial status. But the interpretation of a law is always changing because courts who are tasked with interpreting the laws are always changing. And as society evolves, the law usually evolves with it, just like the Constitution has been around for the entirety of our national existence. Yet the interpretation of the Constitution is always being done. It is a living, breathing document because the courts interpret the language of the Constitution based on societal changes like we have now. So fair housing is a finite law. It has specific statutory words, but how it's interpreted changes through time. And so in the context of sexual harassment in housing, the existence of that is really one that came into being as a way to mirror what most Americans know about sexual harassment in the workplace. The concept of workplace sexual harassment being illegal is something that we now all have as part of our collective consciousness after a couple of decades now of being aware of that law in the employment side of things. And what HUD came to the conclusion is that it was time to translate that from one context into another where it is equally appropriate, and that's in the fair housing side of things. Being able to rent an apartment without having to consider sexual issues is an important part of how HUD believes the Fair Housing Act should operate, in other words. It's not foreign to anybody who's been around and is an adult that there are always opportunities for people who are interested to try and make sexual advances, especially if they happen to be in a position of power in regards to the other person. In an employment context, your boss has immense power to make sexual advances if they choose to because of their power disparity. In a housing context, the same thing can be true. In a housing context, the person who has the housing, even if it's not rental housing, if you're selling a house, the same thing is true. The person who has the housing is in a position of power superiority to the person who's seeking the housing. The person seeking the housing has inherent incentives to try and do whatever it takes to get the housing they need. That makes it easy to be taken advantage of by someone who is interested in being a ne'er-do-well about it. And so HUD really decided, back in 2016, they felt like it was time to create some specific rules that said so out loud, that said it is a discriminatory act for you to engage in conduct that premises a housing transaction of any kind on or infects a housing transaction of any kind with sexual favors, sexual harassment. And so that really changes the ballgame for a lot of rental housing providers in ways that we'll talk about as we get closer to the end of the seminar. We'll deal with that. One of the key pieces of that, though, is recognizing that the landlord's obligations under the Fair Housing Act now extend to dealing with resident disputes where residents are claiming that they feel harassed and that they feel something like being sexually taken advantage of. In exactly the same way that in a workplace environment, it's not about whether you had sex with someone necessarily or whether you were outright propositioned for it. It's even bigger than that. It's an unwelcome environment in a workplace is a sexual harassment item. If your boss is always telling lewd jokes, even if they never proposition you personally, that's still a sexual harassment item in a workplace setting. Well, in a housing setting, the same principle applies. So you're going to see when we get to talking about HUD's actual definitions of sexual harassment in housing, you'll see there's two components. The first component is actual sexual misconduct towards a person in a housing transaction, but the other one is about the environment. Just like hostile workplace environment is a thing that we now all understand, so now is HUD trying to make sure that we all similarly understand that hostile rental environment is the same kind of thing. And so they've got a really great information sheet that Michael's got on the screen now. We'll come back to that as we get later in the seminar and talk about that, the definitions, and some examples. And then I'll give you some best practices guidance on that too. Okay, so with all that sort of as the precursor, let's jump in and do some COVID stuff and talk through that and then come back to the fair housing stuff now that I've sort of wet your whistle a little bit. But everybody wants to talk about COVID. So how do we deal with COVID? So yesterday in North Carolina, the governor announced that come Saturday at 5 p.m., we are allowed to exit the stay-at-home phase of our confinement, and we are allowed to go into a safer at home phase, which he refers to as phase 2. He's going to allow a number of businesses to reopen on a modified basis with lots of safekeeping and best practices guidance as part of his permissions. Bars are still not going to be allowed to open. If you haven't heard that, restaurants will, and they'll be allowed to engage in conduct. Many other critical components are going to reopen as well. Day camps and overnight camps are going to be allowed to operate starting Saturday. So parents, those of you that are worried about how you're going to care for your kids this summer, you'll have camp options that will be available, and they have some pretty strong guidance about what the camps have to do to maintain safety and how they social distance children and things like that. So there's all kinds of good news in that front out there. One of the bigger issues is, of course, swimming pools can open Saturday at 5 o'clock, and that means everyone needs to be mindful of their own personal amenities on your property. If you're a rental property manager, you've been wondering about fitness centers and pools for a long time now. So it's very clear that pools are allowed to open as long as you maintain the appropriate amount of social distancing and you have limitations on the number of people and those sorts of things. I would refer you to the governor's order to get a bigger handle on that. But from a fair housing perspective, let's talk about this. If you have residents who have disabilities or are otherwise protected under one of the classifications of the Fair Housing Act, they have special unique rights to request reasonable accommodations under the Fair Housing Act. If you have a disability in particular, you have the power to request a reasonable accommodation under the Fair Housing Act. So in the time of COVID, however, that creates a lot of weird situations because the government is mandating what you can and can't do and how you must or must not do it. So what takes priority? If you are an operator of a swimming pool and you have been told by the governor that you may operate your swimming pool, but you may only do so in the following fashion, what if one of your residents comes in and says, I need an accommodation about that? Well, that's something that you're going to have to be ready for. You're going to have to be wary of these things. What if I have one resident right now who is at an apartment community that has a multiple chemical sensitivity disorder. If you've had a resident like that in your time, that means that they have a unique susceptibility to chemical smells and chemical odors and off-gassing from any number of substances that are commonly used, whether they're cleaning agents, whether they're paint, whether they're carpeting, all of those sorts of things. And so a multiple chemical sensitivity person is someone with a disability and someone who has a right to reasonable accommodations for the standard practices and procedures of a community. For instance, that person at that community had already requested an accommodation relating to the renovation of the building she lives in that was supposed to happen before COVID arrived. And they were going to be repainting the entirety of the exterior of the building, including the hallways and the common areas, and sprucing it up, which is great. But because she has to walk through those areas to get to her apartment, and she has multiple chemical sensitivity, she requested an accommodation that relates to the type of paint used and being able to schedule time away from her premises so that she can live in a building that isn't being painted while the painting dries and while the off-gassing happens. All legitimate fair housing requests based on an actual chemical sensitivity syndrome. Well, what about now? So if you're reopening your office and you're going to engage in the full practice of leasing from a professional leasing office that is now open for business again with limitations and with 6-foot guidances and tape on the floors and all those things, but also with a very specific regimen of cleaning that has to be done in accordance with governor's orders. There are no alternatives to the recommended cleaning substances that are recommended for use in combating COVID-19. How does that play into a multiple chemical sensitivity syndrome residence request for accommodation? I need to come to the office to pay my rent, but I need the office not to be cleaned with those recommended cleaning agents. That's an actual request. It's a legitimate question. And the answer is, I don't know who plays out or how that plays out in the real world setting. You are likely going to have to spend time with the assistance of counsel crafting a response that says, we have governmental obligations. We can only clean with recommended agents. If you have a recommendation about what cleaning reagent you would like us to use based on your multiple chemical sensitivity, we will evaluate that. But we cannot promise you that we will not follow the government's directives. And so you may have to consider other alternatives. If it is impossible to meet the government's requirements for cleaning without putting your resident in harm's way, then you may have to make accommodations that are in the order of providing them alternative methods with communicating with the office. You might have to do something unusual like, we will come to you and make a house call to solve the problem. If the office can't be kept free of chemical sensitivity, then maybe you might be in a situation where you have to schedule a meeting with your resident at their apartment so that they can have access to the leasing staff that they're entitled to have a meeting with the manager, but in an environment that doesn't trigger their multiple chemical sensitivity syndrome. Think about that. When's the last time you had a house call meeting as a manager of an apartment community with one of your residents? Probably never. But yet that's the kind of stuff you have to consider in an environment like now, where we have this unusual set of governmental restriction with governmental directives that are so specific that they are basically non-negotiables. But yet you have people with disabilities who need accommodation. And so you have to start thinking outside the usual box. You can't just use a different chemical because you're not allowed to. So you have to do something else. Like, how do we operate the office in a different way then? How do we give the resident access to our office staff? The answer might be you might have to take the office staff to them. Same thing for rent collection. If the resident is needing accommodation to be able to pay their rent in a different fashion and you don't have a drop box, you might have to consider, if that resident has multiple chemical sensitivity, they can't come to the office because of the daily cleaning regimen or the fogging that you're engaging in or whatever it might be. They might say, I need you to install a Dropbox so I can pay my rent by check because I'm elderly, I don't have access, I'm not any good at online, I don't do online banking, and so I need to pay by check, but I also can't come to the office to drop it off. You might have to consider installing a Dropbox just for that purpose because that's a reasonable modification. It's not your desired outcome, but yet it's not unreasonable. They're not unreasonably expensive, and they are doable. But those are the kinds of accommodations you might have to consider for someone like that who's dealing with an issue like this. You know, another resident might have in opening your pools, let's say, you might have another resident that has a skin condition that necessitates their ability to stay out of the sun and to use umbrella seating. Well, if you have limitations on how many people can be in the pool and you have a limited number of umbrellas, and the person who wants to use the pool can never get an umbrella because those are the first things taken these days, and there's a limited opportunity because of the new protocol that you have in place per the government for opening and operating your pool. That person with a disability, you know, they have a skin sensitivity to sunlight, and so they can only use the pool and can only enjoy that amenity if done under shade. They may have a request where they need a personal sunshade or be allowed to bring their own personal sunshade to the pool, even if your usual policy is we don't allow personal umbrellas or things of that nature to be brought to the pool. You might have to strongly consider that in this environment, that you make an exception to that normal policy because of the limitations you're operating your pool under right now in phase 2 of the governor's orders for lifting the stay-at-home order. Those are the kinds of accommodations that are completely COVID specific that you may never hear again because the daily operation of your pool may never look like this in the future. But for right now, this Saturday and Sunday, those are the kinds of issues you may hear from people, and you need to be prepared for addressing those as the fair housing concerns that they are. Any request for any accommodation to any policy is a fair housing problem waiting to happen. And let me, while I'm on that, let me remind you that one of the most important parts of the Fair Housing Act from a operator's standpoint, you, the professional real estate manager or assistant manager or leasing associate, you are considered by the government to be the professional in this situation. The government expects you to help the resident exercise their rights. Do not let yourself fall into the lazy way of thinking of the Fair Housing Act as a me versus my resident problem. It's not supposed to be that. And too many people, too many clients talk to me in ways that seem to indicate that they view fair housing issues as the resident versus me. And it's not intended to operate like that. The government expects you as the professionals to be ready to help residents receive the rights that they're entitled to under the law, not to serve as a gatekeeper to prevent them from getting their rights if they don't do it right. You know, put that in air quotes, if you will. If the resident comes to you and says, I really wish there was, I'm elderly and I have a fixed income and I only pay the rent with my Social Security check and it never comes until the 9th day of the month. I really wish there was some way that I could pay my rent without it being late every month by paying you on the 10th and having that be okay. That's one that, you know, comes up regularly in my practice. I teach it all the time. Because the Fair Housing Act expects you to be the professionals, the government, HUD, expects you, when you hear a resident say that, the government expects you to understand that means they're requesting an accommodation. Even though they didn't say, I would like your reasonable accommodation form, please. I have an accommodation I would like to request. You cannot make that the gatekeeper to giving people accommodations. If they mention that they wish that a policy was different and that it could be applied to them differently, that is a reasonable accommodation request. The resident is not, in other words, required to use magic words before they get an accommodation. If they tell you, I wish there was some way you guys could take my rent on the 10th, that is an accommodation request. And you, the professional, are supposed to know that and are supposed to then say, you know what, let me give you my reasonable accommodation form. And if you'll fill that out, put it in writing so that we know for sure what you're looking for, we'll be happy to help you and consider it. But for the record, I say this almost every time I teach fair housing, if you have a resident that is elderly, they're almost certainly disabled in some form or fashion. And if they are, and they are on a fixed income, they are almost always entitled to an accommodation on the issue of when is their rent considered late. When is their rent due is a substantive, easy to solve problem that is an accommodation that doesn't cost you anything and doesn't create any undue hardship on the landlord at all. And as such, it is the definition of an accommodation that must be granted. There is no ifs, ands, or buts about it. If you have elderly residents on fixed incomes that have any sort of disability at all, and they say, I wish that it was easier for me to pay my rent when I get my government check, the answer is you can do that. And we are basically, as landlords, required to let you. All you have to do is show us that you have a disability. Tell us that you have a disability, or if we already know you have one, then we don't need that. And provide reasonable indication that there's a disability-related need. If they show you their Social Security statement, which says every year you get a new Social Security statement, and every year it says you'll receive this amount of money on or before this day every month. If they bring you that, then that's all you need. And every resident in your community that's ever done that should be getting a change in their rent due date. And most landlords, when I teach this to a room full of people, I see at least half the room with wide eyes and hands raised like, well, but, you know, and I get that a lot. But this is one of those topics that I think just sort of evades most people's mindset. Well, what about, don't they have an obligation to manage their finances so that they know when their rent check or when their Social Security check comes in? Why don't they have to manage their finances better? And the answer is because that's not how the Fair Housing Act works. Again, you're the professional. The Fair Housing Act expects you to help the resident receive maximum benefit of their housing, not expects you to be the gatekeeper who says, well, you only get the accommodation if you've both A, used the magic words, and B, shown that you've managed your finances better, and that's your responsibility, not ours. It doesn't work like that. It's the opposite. The Fair Housing Act expects you, the professionals, to help your residents when they need help because of their age, disability, or other limitation that's covered by the Fair Housing Act. And I think that piece gets overlooked a lot by a lot of property management professionals that either got trained the wrong way or that haven't spent enough time in the industry to know better. But this is not a game of gotcha. This is not a game of, well, unless you do the following things in the correct order and then say, Mother, may I at the end, you don't get the accommodation. But I have a lot of clients for whom I think then deep down inside, that's how they think of them. And if you find yourself, or if you know someone like that, dissuade them from that view, because the government is getting more and more concerted in their effort to combat lingering problems in the Fair Housing Act. And one of the lingering problems is that kind of mindset. That's old-fashioned mindset, old-fashioned thinking that the resident has a hurdle to jump over before they get their accommodation is a bad way of thinking of it. And there's too many ways that happens even now today. So keep that in mind as we go through this COVID process. Remember that any resident that comes to you and even says something as simple as, I wish that we could do something different, that is something that should be immediately recognized as a possible accommodation request. And if you're not following up on it, if you're not diving deeper into that, asking them for more information, giving them a form requesting that they give you better statement of what they're looking for, you are doing yourself a disservice. And I assure you that in a pandemic where so many people are struggling to make ends meet and to get by and to get through to the other end, to try and find some level of normal again, any difficulties that they suffer that are additional to the pandemic itself are ones that I think are going to be more likely to be litigated about. I think people are going to view any slights that they have to bear during this time as even more heightened because of their increased awareness of the challenges they face in daily life right now. And so the act of making any piece of their life harder is one that I think creates a lot of risk of claims being made that might otherwise have passed unnoticed in normal times. And so I think being sort of on red alert and reminding your staff, the people you work with, that residents who come in, and as we do new things and as we reopen amenities and as we add new policies and create new procedures that never existed before, all of those things are new and different, and all of them are going to be subject to questioning, challenging, or requesting to be changed by residents. And I think it's really important to remind your staffs that no policy is fixed in stone. Nothing can be perceived as mandatory. Even something like, we have to use the government approved cleaning reagents to clean our office every day. Even that has to be considered as a possible modification. And everything else you do is less severe than that. You know, policies about how you operate your pool, policies about when you reopen your fitness centers, policies about to whom you reopen them and under what circumstances, policies about how you make your fitness centers accessible to people that have accessibility problems, how you address your pool accessibility issues. All of those things, your leasing office, its hours, its accessibility, every single one of those things are new policies that you're putting in place with modifications from the usual practice that existed in February. And now your new policies and procedures relate to what you believe you've been told by the governor and what you believe the governor is requiring you to do. Doesn't change the fact that every one of those is a policy that could be modified if an accommodation request was made and that accommodation was reasonable under the circumstances. So lawyers are invaluable in this context. There is no one right answer for when is an accommodation reasonable or when is it not. Financially is one piece of the puzzle. Does the accommodation cost a lot of money? Then it's probably unreasonable, but not necessarily, depending on the other alternatives. But all of those things, when you have residents that are expressing those concerns, it's going to be doubly important now to make sure that you're reaching out to your counsel to request legal advice about examining these issues. They are not going to be simple. They are not going to be push button answers. In responding to changing policies as we go through the phases of this reopening process, your policies are going to keep changing. And so every time you change a policy, you have a new opportunity for someone to request an accommodation based on what the new policy is or what they need. And so there's just this never-ending cycle of mindfulness that you as the apartment association professionals need to be engaged in. The mindfulness component of what you're doing in an era like we are in now is so important and so hard to understate. I cannot overstate it for you that the obligation to help your residents is more important now than ever. Nobody knows what we're doing. We're all making this up as we go. It is unprecedented. It's never happened in anyone's lifetime. And so as we go forward, being mindful of what those things are is super important. So in the NAA best practices document, there's some other things that we want to talk about. The guidance document mentions collecting of rent. We talked about that a little bit. You know, still be mindful as we go forward now about making accommodations for people that need to pay their rent in alternative fashions. Late fees, another component of collecting rent is the late fee component. Again, whether or not you waive late fees or whether you're required to waive late fees, there's a statute, the CARES Act, that deals with whether you're mandated to forego late fees for the moratorium period. But if you're not, and you're choosing to waive late fees as a courtesy, remember that that's a policy. And when you reinstate late fees and you no longer are waiving them as a courtesy, you've changed that policy. So now if you're reinstating late fees, that's something you need to remind your residents of. And if that change triggers one or two elderly residents to come to you and mention, gosh, I know that you're reinstating the late fees, but really in this environment, it really would be helpful for me, especially now, if we could change the day my rent is due so that the late fee doesn't apply to me until the 15th of the month instead of the 5th of the month. You may see people come to you now as you reinstate your late fee protocols that are triggered to have that conversation when it never occurred to them before COVID happened. Being aware of that issue is an important part of this. So as you change your policy, remember that that change, just going back to the regular state of affairs of having late fees that are due, that are charged to their account on the 6th of the month, might trigger some people to come in and speak up about wishing their rent could be due on the 10th instead of on the 1st. And if you hear those people come to your office, you need to be mindful that that's a fair housing reasonable accommodation request. May not have happened before. They may not have thought of it before, but now we've got them. Payment plans, another one that's got a fair housing overlay to it. So lots of people are communicating to their residents almost universally that in this time of crisis, if you are suffering a hardship, we are willing to work with you. We are offering protocols that might assist you. And one of those is a repayment agreement or a payment plan. And NAA has created some forms that are in there. Michael's clicking over to it as we speak. You know, and so most of us have heard about these repayment agreements and notice of temporary waiver of late fees. All those documents that were created by the NAA for assistance to all of its members back in March are still out there. But new people are being affected by COVID as we speak. You know, lots of people are struggling through and hoping for the best, but then their business goes out of business. For example, just yesterday, Pier 1 announced that it had been trying to survive and it just gave up. We're closing all of our stores effective such and such date. And even though we were trying to survive with bankruptcy protection, we can't do it. And now we're just going to give up. Well, those people who work for Pier 1 and are still operating their stores are now going to have a COVID related impact because they're going to be let go because Pier 1 couldn't survive through the pandemic. Those people didn't have a problem in March, didn't have a problem in April, and may not have a problem in May. But come June or July, those people may have an adverse impact from COVID. Revoking payment plan arrangements, revoking your desire to enter into payment plans with people may be something that a fair housing accommodation request might tag. You might get a resident that says, I think I need a reasonable accommodation because of the change in status I just had now that Pier 1 has closed its shop. And if you were to respond and say, well, we don't offer that program anymore, you have a fair housing issue because the resident could easily claim that they think you're not offering that program because they're a member of a protected class. And other people got a payment plan and they didn't. Now, that doesn't mean that you did it wrong necessarily, but what it means is that there is a fair housing issue that needs to be investigated. And for those of you that have never been in a fair housing investigation, I assure you, you don't want to be. The fair housing investigation is really a lose-lose proposition for landlords. Even if you prove you were right and you prove that there was no cause to believe discrimination happened, you have still lost because you've spent countless hours responding to the complaint, providing documentation, probably being interviewed, and you've spent lawyer fees having a lawyer help you get to a resolution, all of which means that you won, but you still lost. Your budget still takes the hit. Your time lost from work is still a factor, and you don't win a prize by winning. The tenant doesn't owe you any money. They're entitled to file a fair housing claim anytime they want to, and so avoiding them is really the mission. It's not about winning a fair housing claim. It's about not having a fair housing claim. So with that mindset, you need to be cautious about how you deal with people who might be experiencing similar symptoms, similar effects under COVID rather, and yet bringing those to your attention at a different timeline from people who had these issues in March and April. So creating payment plans is a great idea, but being mindful of the need to not just discontinue that payment plan and tell everybody else, too bad, we're not doing it anymore. That's a piece of legal advice that you're going to want to think strongly about before you discontinue a program that provided real help for residents, and before you just decide to stop doing that in the future. You're going to want to get really good advice about how to do that how to notify people that you're doing that, how to notify people that you're changing that policy, discontinuing the payment plan policy, whatever it might be. Those all have fair housing overlay items or concerns that you want to take into account. Make sure that you don't overlook that and don't just knee-jerk tell people, sorry, payment plans are no longer available. That would be unwise. Resident communications, another one that's in our little handout here, item 4. NAA recommends, the most important thing that you can do as owner and manager is communicate with your residents. Ask residents to communicate with your property manager if they aren't able to pay rent in full because of the pandemic. Consider asking affected residents to provide documentation from an employer about their affect. All of those issues are super important because as you create your programs, or now that you've created them, and while you're operating your programs, providing rental assistance to residents that have been affected, make sure that you have a really strong consistency component to the communications about the program. Nothing is worse than having a good deed turn into a bad problem. Offering residents help in a time of crisis is a good deed, but doing it in a way that creates inconsistency would turn it into a disaster if a resident were to find out that, let's say, their neighbor got access to a repayment plan, but they didn't because the policy at the property was, well, we only tell residents about the repayment plan if they ask. And that was a question that I got from a lot of clients at the beginning of this pandemic was, well, that's what we want to do. We want to make it we'll offer it if you ask for it. I was like, you can't do that. I would tell people you cannot do that because it creates a difference in information. There is no doubt that some people in your community will find out about that plan, that protocol, the secret protocol, the if you ask, then you get told protocol. They will hear about it and other people won't. And the people who didn't hear about it will find out from their friends and neighbors that they, the neighbors, got an opportunity to enter into a repayment plan. And they will say, well, how come I didn't get that opportunity? And if the answer is, well, we only told people that asked, then that is almost guaranteed to create a feeling of disparate treatment, which is easy to characterize as discrimination if one of the parties was a member of a protected class and feels like, I think they just didn't tell us because we're a member of this protected class. That's a fair housing claim waiting to happen. And so communication in NAA's terms here, resident communication is invaluable in a time of crisis, especially when there's changing policies. When your policies are different, when your policies are changing, failing to tell everybody exactly the same information is a crisis waiting to occur. And so as you go about this, changing policies and making these things known, if you're making accommodations for people, again, be mindful of the issues. One of the things that might happen is if you have to make an accommodation for a resident at the pool and allow them to bring their own umbrella into the pool, let's say. If, again, going back to my example, if you have a skin condition and you need a sunshade, but there's only 2 sunshades in the pool area and there's only ever been 2 sunshades in the pool area, the resident's asking to be allowed to bring their own sunshade, which normally would be prohibited. Some residents are going to say, hey, I want to bring my own sunshade. How come I can't? And your answer needs to be cautious. Remember that you can't talk about other people's disabilities. You can't tell the resident why Bob with the skin condition was able to bring his own sunshade, because that would be talking about Bob's health condition, broadcasting that he has a disability. In exactly the same way that you can't talk about why someone has an emotional support animal when someone else says, I want to have a pit bull too, how come they get to have a pit bull? The one right answer when you're dealing with situations like that, there's only one and there's always only been one that suffices and keeps you out of harm's way. And that answer is to say, I'm sorry, I can't talk to you about other residents or their particular situations without their permission. Any more than you would want me talking about your personal business to any other resident who walked into the office with questions about what you were doing. And that answers everybody's questions all the time, but it's the only one that matters. So if someone, if you had a situation where there's someone who brings their own sunshade in, skin condition, and so if you had to make an exception and allow him to bring his own sunshade, you can't say that. That would be revealing Bob's status as a disabled person and revealing that he has a medical condition, all of which would violate his HIPAA rights under federal law. So you have to instead say, I'm sorry, I can't talk to you about other residents or their personal business. any more than you would want me talking about your personal business without your permission to other residents that came in here and talked to me about you. And that's it. That's the answer. It's the only answer that applies and suffices in all circumstances, and yet doesn't violate anybody's rights and doesn't create a possibility of you being accused of wrongdoing. So remember that as you deal with issues like this, when you make accommodations for people that are visible, it's important to remember that you're not allowed to talk about them because they got the accommodation due to a disability.
Hey, Chris.
Yeah.
We've got a question.
Yay, all right.
Unfortunately, I don't know who it's from because they chose to remain anonymous. So
that's okay.
It says, I apologize for my question in advance, but I don't understand changing the day rent is due as a reasonable accommodation. I feel like it goes against everything we do to be consistent, because once we change that for one resident and that resident talks to other residents, and before you know it, everyone has a different rent due date. And why have a lease break fee if Sally Sue can request we not charge it as a reasonable accommodation since she suddenly got a promotion out of state? I think there would be a reason for residents to get around everything, and that defeats us being across the board and consistent.
That is a really, really great question. So thank you, whoever you were. All right, two things. One, you are not required to be consistent. The Fair Housing Act exists specifically not to mandate uniformity. The Fair Housing Act exists to mandate that everybody, every American, have the right to equally enjoy or to equally be opportunity, to give the opportunity for equal enjoyment of housing. If a resident has a disability, and that disability, let me give a better example. Old people, I use old people all the time because every old person I know has a disability of some kind, medical condition that is a disability. But let's use one that isn't. I had a mediation not too long ago with a resident who was disgruntled because he is a disabled military vet. He served in one of the conflicts in Afghanistan, had PTSD, and had one of his legs amputated as a result of an accident with an improvised explosive device. And he was the breadwinner for their family. His wife is a stay-at-home mom of 3 kids. He was a military guy. She was a military wife. They live off of his military income and his disability check. He can't, so he's a very easy example. Well, so their entire family income revolves around his disability income. Otherwise it was a 42-year-old, otherwise healthy-looking person, but for his PTSD and his amputated leg. Both of which are disabilities, both of which entitle him to live on a fixed income and mandate that he live on a fixed income. And so when his check arrives every month, that is the only income that his family gets. If he walks in and says, that's the only income we get, and I get that income as a disability check from the government, I would like my rent to be due the day after the disability check is supposed to come, you don't have a choice. You must let him do that. But here's the thing. You're not allowed to talk about that because of the disability status. And just like I told you, if some other resident walks in and says, hey, my neighbor Bob, he doesn't have to pay his rent until the 10th of the month. How come I can't pay on the 10th of the month? Your answer is the same. I've given you the reason how you can diffuse this. You say, I'm sorry, I can't talk to you about other residents without their permission, any more than you'd want me talking about your business with other residents if they walked in here. But your rent is due on the 1st. I'm sorry. I can't talk about any other resident or when their rent might be due or not due. But rent is due on the 1st. And that's it. But you do have to do that. It is a mandatory effect of the Fair Housing Act that if someone like the guy I described, 42-year-old breadwinner for the family who gets all the income by disability check, walks into your office and says, I wish my rent would be due the day after my disability check gets here, you don't have a choice. That is a mandatory, you must do that. Otherwise, you are committing a Fair Housing Act violation for which you would lose badly. There is no defending that. And it doesn't matter that other people might have disabilities in your community. And if one of them says, hey, to their disabled friends, let's say they have a group at the community that's, the disabled military vets at their community. If you lived in Fayetteville, there are lots of apartment communities that have lots of disabled vets. Let's say they have a poker group, and he told everybody in the poker group, hey guys, the other 7 of you, you should let them know that you get your disability checks and you want your rent due on the 10th. You still have to do it. Even if 10 people are getting their rent changed to the 10th of the month because they're all disabled military vets, you still have to give them all that accommodation. You're the professional. The government expects you to make those accommodations so that those people can have the reasonable enjoyment of the premises just like everyone else. And that's just the way it is. The government knows that that puts a burden on you, and it does require you to keep track of who pays on what date. And the government says, we expect that that's part of the job of being a professional in this industry. And that's really how it goes.
We have a follow-up question while you're still talking about it. I recognize this from one of my videos last week in my CAST certification course I'm doing. Are we allowed to ask for proof of certain situations in order to provide reasonable accommodation?
So yeah, the reasonable accommodation standard has always been the same, is that you're allowed to ask, do you have a disability? Yes or no. It's literally like third grade. Do you want to, do you want to be my boyfriend? Yes, no, maybe. You can ask someone, do you have a disability? Unless it's obvious that they do. If you know that they are, sight impaired, hearing impaired, if you know they're in a wheelchair, if you know that they have an artificial limb, you can't ask them if they're disabled because you can see that they are with your own eyes. But if you don't know, if they have PTSD, which is a disability, but you can't see it, you're allowed to ask the question, do you have a disability? And if they say yes, then you're allowed to ask for reasonable third-party verification of the disability-related need for the change. So in the case of disability payment status, all you have to do is ask for reasonable third-party verification, which they readily have available because the government sends a disability statement every year that says your disability payment will come on this day of the month. Well, the disability check is proof that it's coming, and the statement itself says when it will be due or when it will arrive. And so in the context of my example, that's all the documentation you would need because that answers all the questions. Clearly, they're receiving disability income, and clearly it won't arrive because the government said it won't arrive until the 8th or 9th of the month. So you can tell from that one form exactly whether or not they meet the disability requirements for an accommodation like that. But yes, you are allowed to ask in every context, whether it's an emotional support animal or rent due date, you're allowed to ask for third-party verification of the disability-related need for the change.
And in the situation that someone's rent date is changed as an accommodation and they bump into someone else who's paying rent on the 1st and they have a problem with it and come in upset and we say we can't discuss other people in their situation, can't the disgruntled person say we're discriminating and attempt to take legal action?
Well, I mean, they could say whatever they want, but those people aren't going to succeed if they haven't actually made an accommodation request. They're not entitled to claim that they were being discriminated against if the reason for your change was a reasonable accommodation under the Fair Housing Act. You would succeed and you would win that claim. And again, you can't prevent all claims. And if somebody were to file a claim because you were doing what the law mandates you to do, that would be a case where there's a no cause finding almost 100% of the time. If you said we didn't tell them what the problem was, and we didn't give them an accommodation because they didn't have one, that's a claim that you would just have to defend because it's the right thing to do. But yes, you can't prevent everybody from feeling discriminated. But if you're doing it right and that creates a feeling of discrimination, that's okay. The folks at HUD and the investigators are obviously trained and well honed in that idea, and they would very clearly settle on that as the reason to deny a claim of discrimination.
And back to property amenities, would it be considered a fair housing violation if we choose to not open our pools at this time?
No, it's not a fair housing violation, no. The argument that residents will make is that they're being deprived of the use of an amenity that they believe they're paying rent for, but that is a legal argument that depends on the terms of your contract and so far has very little traction and is very unlikely to be successful in any form or fashion other than them being grumpy about it. But most people's leases make amenities a free service, not a paid service. And the dilemma would be if people are paying amenity fees as part of their leases, which was a fancy creation that gained some traction here in the last 2 or 3 years. If you're charging them a fee for use of the amenities and then not providing the amenities, that's a question you're going to want to talk to your lawyer about. How do we address that? What do we do with that? But for a regular situation where there isn't a specific amenity fee, there's just rent for the premises, and we include amenities as an enticement, that doesn't create the same level of concern because the premises are still available. They're still getting the full value of what they rent. The amenities just aren't available due to a health crisis. Most people's leases, if you're using the AANC or the NAA lease, there is a clause in those leases that relates to what's called force majeure, which is a French term for obviously major force, but what it means is a force out of your control, an act of God, in this case a pandemic, and that clause is what you would look at to highlight for residents that says right here, in the event that there is a pandemic like this, we are excused from performance of any of the obligations under this contract that are prevented by the pandemic. So if health concerns are such that you can't open your pool safely, or you're not confident you could open your pool safely and you choose not to, there's not really a lot the resident can do about that. So have your lawyer look at your lease and make sure that they highlight for you the force majeure clause, so you can make sure you've got that answer handy if a resident comes in to complain.
And granting a change for the rent due date, that doesn't have to be accepted across the board for any reason, right? So if a resident says, well, my car payment's due on the 15th, so I want my car payment's due on the 1st, so I want my rent due on the 15th.
Yeah, remember that accommodations, changes to policy, are only required as an accommodation for a disability. And so if you have a disability and you have a disability-related need to change a policy, that's when the landlord is obligated to do it, but not just because it's convenient for you economically. They have to, in order to get your rent due date changed, you have to establish that A, you have a disability, and B, your disability creates a situation where you have a fixed income issue that needs to be addressed by changing your rent due date because of the fixed income, which is a result of the disability. So yes, it's not for everybody. It's only for people who are disabled and whose disability creates the need for a change in the payment date based on fixed income checks arriving on a certain date, for example.
Okay. Well, it's 11:59 and you've answered all the questions that have come through so far. So I'm not sure if you still have any more to share, but we're caught up at this point.
That is good. Flip over to the sexual harassment and housing document just so I can introduce it to people.
The new one from the 29th?
No, well, let's do that one just before we sign off, since we started about 5 minutes after. So on the 29th of April, Secretary Carson of HUD, Michael's got it up on the screen right now, he put out a press release to commend the Attorney General of the United States, William Barr, because in response to the April focus of sexual harassment in housing, because sexual harassment housing is illegal, Attorney General Barr partnered with or tagged onto that and announced at the end of April that his office, the Department of Justice, was going to be engaged in every effort using all of their resources to investigate and prosecute fair housing related crimes dealing with sexual harassment in housing. And so Secretary Carson put this notice out there to tell people, so when you, my clients, hear seminars about this and think about the issue of sexual harassment in housing, this is important to note. The Attorney General has paid attention, and the Attorney General has devoted his office's resources to participating in and investigating and rooting out and prosecuting, if necessary, offenders under the sexual harassment guidelines. So make sure that this is not just an esoteric, Chris is bringing this up because it's an interesting topic. This is a real thing. And the government is spending real energy trying to look for, find, and hold accountable people who are violating the law. So do not take it lightly, is the message of that. And then the last one is the sexual harassment and housing document that HUD put out. It's a quick little 2-page resource that talks about sexual harassment and housing and gives you examples. So I mentioned there's 2 types, quid pro quo and hostile environment. The quid pro quo liability is easily defined as this for that. It is, you scratch my back, I'll scratch yours. And in that type of liability situation, a housing provider or a member of the housing provider staff is engaging with residents in conversations that result in the resident believing that the housing provider is asking for favors in exchange for services. I can give you a break on your rent renewal rate if you give me blank sexual favor, for example. That is a quid pro quo. I will do something special for you if you do something sexually special for me. That is easy to recognize, and we all sort of inherently know that that would be wrong. The problem is that it still happens. And that's what HUD is, that's why they're focusing on it. In fact, HUD in April included in one of their press releases that they had prosecuted a California landlord who had a property manager who was doing this to multiple residents and finally got caught. Two of the residents got together and filed a claim with HUD for sexual harassment housing violations. And HUD settled that case for $65,000 apiece. The property manager was required to be fired, and the company paid $65,000 to each of the women that filed the claim against him, just as an example. So the seriousness with which HUD takes this issue is substantial. And in very real terms, that did just happen. A property manager was engaging in a pattern of telling female residents, I'll do you favors if you have sex with me. And despite the fact that that seems ridiculous, that is actually what's going on out there. So being aware of it and being mindful of it is important. The second type of harassment is the hostile environment harassment. And this one is, again, the one that's akin to your boss who tells lewd jokes at the office all the time. He's not actively propositioning anybody. He's just being boorish and acting in a way that is uncomfortable for others. Well, the same is true in the context of hostile environment harassment. A hostile environment harassment occurs when a housing provider subjects a person to severe or pervasive, unwelcome sexual conduct that interferes with the rental or conditions of rental of their housing-related services. What that means basically is that if a resident feels like they are being affected in their use of or enjoyment of their rental housing by some conduct by other people, like the boss who tells lewd jokes. If she lives next to, like say a female resident lives next to a resident who is constantly whistling at her in the parking lot like he's a construction worker in New York City, and she gets that every day, he's not propositioning her. He's not actively trying to trade this for that, but she's being subjected to unwelcome, pervasive sexual conduct. Catcalling is clearly and unmistakably sexual in nature. And she's being subjected to it on a severe or pervasive basis. Virtually every day or 4 or 5 times a week she gets catcalled. That's pervasive. That affects her enjoyment of her apartment. I don't feel comfortable even getting out of my car and walking to my door if I know that he's home from work because I know he's going to look out his window and whistle at me. That's the kind of sexual harassment that's an environmental harassment situation. Now, you didn't create it, and this is the part that's most important, and we get to end on this note. You didn't create this situation. And for the veterans of the industry, you'll recognize very quickly that this liability changes the game for you substantially. You are no longer able to brush off incidents like that one that I just described as a resident versus resident issue that they'll just have to work out amongst each other. HUD has now made sure that you know as a housing provider, it is your obligation. If that young lady walks into your office and says, I have a problem, I'm being subjected to sexual conduct by my neighbor, he whistles and catcalls at me 3 or 4 times a week when I'm walking through the parking lot, you can't sweep that under the rug by saying, well, that's just you and your neighbor, you'll have to work that out. That is sexual harassment, and in housing, you have an obligation under the Fair Housing Act to investigate and remediate the problem by probably evicting the neighbor who's engaging in that conduct. But you need to investigate the issue no matter what, so that you're doing your due diligence and protecting your residents' rights to enjoyment of the property and to enjoy it free of unwelcome sexual conduct that interferes with their enjoyment of the conditions or privileges of the housing. That would include common areas, amenities like the pool, like the fitness center. If a female resident says, every time I go to the fitness center wearing my workout gear, my neighbor sees me go and he immediately puts gear on and follows me there and works out so that he can stare at me while I jog on the treadmill. He's not doing anything officially other than ogling her while she works out in her workout gear. That's sexual harassment in unwelcome sexual conduct that interferes with the environment, like a fitness center that's provided as an amenity as part of a rental housing contract. Those are the kinds of situations that sexual harassment in the hostile environment context, that's how they manifest. And when you hear about them from your residents, when you hear complaints, you need to treat them as fair housing issues, not as one resident versus another resident. Be mindful of that and know that that's how HUD expects you to handle these situations going forward.
Okay, before we sign off, Amanda, I am going to get your question, but before we sign off, I want to remind everybody we did record today, so a link will be sent out later, and we'll also post it on our firm's YouTube page, so you can check it out there. But Carrie will also send out an email. We'll provide that link to her. So if you have to go, you're certainly welcome to sign off at this point. Make sure that Carrie has your email address. She mentioned that at the beginning, so you get your credits. And we do have one question left, Chris, if you want to hit that.
Yep.
Before we sign off. So Amanda's wondering, if someone gets COVID-19 after we open the amenities, could they take legal action against us?
Nobody knows.
It ties into that email that we sent out this week reminding clients about 4242.
Yep. Nobody knows for sure whether a tenant can file suit, but remember that North Carolina has a Landlord Tenant Act, and in that act, North Carolina General Statute 42-42 deals with landlords' obligations to the residents and to maintaining the premises. 4242A3 says that the landlord has an obligation to maintain all common areas in a safe condition at all times. So if you're opening your common areas, it's important to make sure that whatever protocol you have keeps the premises safe. And I think that is a very real consideration for fitness centers in particular. Pools, I think, have a much different level of analysis because of the outdoor nature of them. But fitness centers, I think you are going to have to spend a lot of time making sure that you have a good plan in place, because the law is not suspended in a time of pandemic. And so if you choose to open your fitness center and you don't make sure that it is safe for use, then I think a resident very well could claim that that was a failure to meet the standard of the law. So call your attorneys, get advice. This one is complicated.
I know at my wife's gym, they want her to sign a waiver to use the gym saying she won't sue if she dies from COVID-19.
Yep.
I said, let me run that by Chris.
Yep. And in North Carolina, our statute says that that you cannot get the resident to waive the obligation. They cannot. So even if you give them a waiver, they still don't lose their right to say, well, it wasn't safe. Well, you agreed to use it even though it wasn't safe. The law says you can't do that in North Carolina. That obligation to keep the premises safe cannot be waived by the resident, even if you give them a waiver form. That's why it's complicated.
Yeah.
Yep.
Well, thank you. Thank you so much for your time, Chris, and everybody for joining us today. Carrie, any closing comments or PTAA business before we sign off?
I would just like to thank you guys for this. I think I speak for the whole crew listening in at how helpful this has been. So thank you all so much. And just as a reminder to the attendees, I will be emailing out your continuing education credit certificate by the end of the day tomorrow. And it should also include a link to the recorded portion of this as one of the many ways Michael's just mentioned that you have access to that.
Okay. Thank you, everybody. We appreciate it.
Very good. Thanks, y'all.
Thank you.
Bye.